Okay, very good. Welcome back, members of the jury. We are ready to proceed. And Ms. Finkelstein, on behalf of Shan Gathright, you may proceed.
Thank you, Your Honor. Good morning. Members of the jury, we have come a long way since you were selected a little bit over 3 weeks ago, and now we have reached the most demanding part of this trial. In just a little while, the fate of Shan Gathright is going to be out of our hands and into yours. If you remember back to jury selection, there was a lot of numbers, scales, questions posed to you over and over, and I told you at that time I wasn't going to hold you to those numbers. Some of us said we didn't really like the numbers. It was just kind of getting a feel for where you guys stand coming into a new scenario. And the reason I said that was because this isn't a test. This isn't a numbers game, not a math problem or an equation. This is most literally a life or death scenario. Soon you will have to decide whether a young 20-year-old man will spend the rest of his life in prison or whether he will be executed. Shan Gathright is not wicked. Shan Gathright is not evil. No matter how many times, no matter how many ways it could be said in the state's closing, he's not a mastermind. He's not a super coordinator or orchestrator. Apparently, he might even be a rocket scientist. The state can minimize or diminish the mitigation list that's in front of you. The state may think that something deserves weight or no weight. That doesn't matter. That decision lies with each and every one of you. The state's opinion or theory is just that. This part of the trial, as I told you in opening, is about the defendants, about Shan Gathright, and it's about each one of you. On several occasions, I heard Mr. Harmon, when he was reading some of the mitigating factors that are on there, say, you can find that mitigating, that's fine. But lucky for you, you don't need permission. You can evaluate that mitigation exactly how you feel fit. Each and every one of them. This is your decision, a personal decision, and you never, under any circumstance, have to vote for death. In the state's close, Mr. Harmon presented a very strong case for why you should find Mr. Gathright guilty. You've already done that. That part's over. Went pretty hard on Mr. Gathright and painted him out as a person who led this whole thing. We wouldn't be here without him. That's his theory, and my theory is that's done to lessen the mitigation. That was done to convince you that what you saw and what you heard from this witness stand this last week from Mr. Gathright's mouth himself shouldn't be given the significant weight that it deserves. But what it actually did was prove that a kid with no motive, no involvement, no history in that, can get wrapped up in a culture that he has no business in. The evidence was overwhelming that Mr. Gathright's life has, and always will have value. Mr. Gathright is a human being worth saving, even in prison. People may think, well, you're in there for life or death. Does it matter? You're in there. Yes, because you heard from Mr. Bonasco all the different ways that you can be useful, not only to the state from a financial perspective, if that matters, but to other people in prison, out of prison, his family that supports him no matter what, sits in here and listens every day. You heard what a positive, optimistic person he is from friends, family, guidance counselors. He can be a light in a dark place. Hopefully he can keep making people smile. Even now, from jail, you heard that he's still asking about other people when he talks to them, trying to keep them in good spirits while he's sitting in jail. While he is facing a death sentence, he's worried about other people. That's not wicked. That's not evil. The theme from those witnesses on Mr. Gathright's behalf, well, he was positive, he was funny, he was witty, he made people feel good. You heard that he was kind and respectful and well-mannered. And you don't just have to take the word of family and friends that know him and, of course, want to come in and they want to save him, they want to help him. You saw it from Mr. Gathright. That young man had the courage to get up there and face you and talk to you and try the best he could to explain his remorse, his accountability, and his worth. And when he was questioned on cross-examination and tried to get riled up, he remained respectful. That's his character. That wasn't a show. He was authentic. He was real. He was honest. He didn't get riled up. He answered every question politely, with "sir" at the end, from someone who was cross-examining him pretty harshly, and who was seeking to have you vote to take his life away. He remained respectful because that's who he is inside. That doesn't change. Now, is that the reason that you should not give somebody a death penalty? Well, that's up to you. And that's why it's your choice. But what it is, along with the other testimony you heard, is that proof that good kids, good people, privileged kids, I guess we want to call them, educated, intelligent, worldly, that those types of kids, Shan Gathright was not isolated or insulated or immune from getting wrapped up in something that he had no business in. He's an 18-year-old kid who is not immune from outside influence, curiosity. He told you himself, yes, I had a privileged life. I had people that loved me. I got to travel. I saw things. I did things. I had opportunity. And I still, after leaving that bubble, saw parts of Jacksonville, parts of a culture that I didn't know were out there. And look where he finds himself. That curiosity from that 18-year-old kid brought him right here. You know, the state said, oh, Mr. Bonasco, who testified, the prison expert, said Mr. Gathright was mature. I think everybody did. I think you can see it for yourself. He's mature. He appeared mature for his age. Well, Mr. Bonasco is basing that on a conversation at the jail for, I think it was a little over an hour. But either way, because he worked, traveled, helped support himself, cared for others, went to school, presented himself as grown, can take care of himself, that might be mature for an 18-year-old. But he's still 18. Maturity on the outside is not the same thing as being a developed adult and having life experiences, having knowledge, having street smarts. It's not the same thing. You can be well-spoken and smart and mature and still make really bad decisions. He is impressionable. He's naive. He was curious. He told you he was easily influenced. That matters. He told you himself that he was more vulnerable to influence and more likely to follow others, probably based on his lack of seeing other aspects of the culture, other aspects of Jacksonville. And we heard that it's pretty rough there. Because he was 18, he was less capable of kind of stopping and saying, wait, maybe this isn't taking me where I need to go, and seeing the end result. He doesn't have that experience or that knowledge. He told you that while he had male influences and guidance in his life, at the times that he felt it really mattered. When Brian Harrington, his stepfather, who was a great guy, divorced his mother 2020. Shan Gathright was only 15. So from 15 till he lands in jail at 18, he didn't have a steady, constant influence in his life when he needed it the most. He's not saying he didn't have anybody. He's not saying all the people that come here to support him and love him weren't really there. They were. But he's a kid. He's feeling his way through things. And it wasn't constant, and it wasn't there for him at those years. And that fact doesn't excuse any conduct. It doesn't remove accountability, but it explains how a young person with so much promise can make a catastrophic decision that could define the rest of his life. That one decision. And I told you in opening that mitigation isn't an excuse. I'm not up here to make excuses for Shan Gathright, and he wasn't making excuses for himself. He wasn't blaming anybody. It's an explanation, and it's a reason. And that's what mitigation is all about. It helps to understand what I'm sure everyone is wondering is how he got here. It's his story. He took accountability. He showed remorse. Remorse is defined as deep and painful and often long-lasting feelings of guilt, sadness or regret for past wrongdoing. Not at the moment. Most people don't feel remorse while they're doing something wrong. They feel it afterwards, and that's what you saw. That wasn't contrived. That wasn't fake. That wasn't for your benefit. It took a lot for him to get up there, and he wanted to. Accountability is obligation or the willingness, which you saw, to accept responsibility and account for one's actions, and that's exactly what he did. He was straightforward, he was composed, he was wholly authentic. And he told you, what led him there, what his curiosity did to him. And you had heard from Maurice Edwards, the state tried to say, he never, one of the mitigators was about, him, his instability or not being able to adapt. And Maurice Edwards did tell you that at a younger age, being that he had some experiences and that Shan traveled and was not as steady in a place, he has a biracial family, that he did feel some sense of instability. Where do I belong? Where do I fit in? And of course you're going to. You're traveling all over. Yes, you're seeing great things, but he's still a kid. And he admits, Mr. Gathright told you, stepped foot in the jail and immediately thought, where did my path veer? And instead of feeling sorry for himself, getting down on himself for this situation that he and nobody else that you heard from saw coming, he cracked his Bible. He told you he talked to God. And he's trying to make the best of a situation that he finds himself in. He said something that I felt was pretty profound, that he said, people are always asking God for something, praying to God to give them something or do something for them. And he thought, I can ask God what he wants from me. even in this situation, he can be a light. He can help people. He can try and turn lives around for kids that he comes into contact with, or adults. In a dark, dark place, he sees hope. He sees a future. And I'm up here asking you to see that future for him. See the hope in him. See the redemption in him. A lot of the questions of our mitigation witnesses and then some of the state's closing was thinking, oh, he's a privileged kid, he had it all. Does that mean he's not worth saving? I would submit to you that it's the absolute opposite. There's a long list of mitigating factors that you'll have in your instructions, and the state went over a lot of them. I think there's 32 for Mr. Gathright. I'm not going to read them all to you right now. But you'll have them when you deliberate. And it's a long list for a reason. It's a long list because in his short 20 years, 18 when this happened, he really made an impression on this world. So it's a long list. Imagine what he could have done if he had more than 18 years. And remember, that's just a list that we're providing you. Mitigation can be absolutely anything that you want. Anything you heard in the first phase, anything you heard in this phase, or just because you don't think that this young man deserves to die. The law says that you can find those aggravators that the state proved to you in the first phase, reminded you of yesterday. You can find that those were proven. You can find that they outweigh the mitigators, and you never have to sentence someone to death. The death penalty in this phase is not whether to punish, but how. It's not about whether Mr. Gathright will die in prison, but about when and by what means. Natural causes are at the hands of the government. The death penalty is not appropriate in this case. Mr. Gathright does not deserve the death penalty. This is the only time you have to make this decision. You can't change it tomorrow. You can't change it next week. This is it. A vote for life does not excuse any criminal behavior. It's not an excuse. It doesn't excuse responsibility for a crime. A vote for life doesn't diminish the life of Charles Jones or the loss to his family or his loved ones. A vote for life in this case is the just decision. It's the right decision for Mr. Gathright. Do not define Shan Gathright by the worst decision, the worst moment of his life. Shan Gathright is a son who's worth saving. He's a friend worth saving. He's a nephew worth saving. He's a grandson that's worth saving. He's a baby brother worth saving. He's an uncle worth saving. I'm asking you to do just that. Thank you.
All right, thank you, Mr. Petrides. On behalf of Isaiah Chance.
Please, the court. I want to thank you again. You're going to get a lot of thank yous today, and they're well deserved. We are at the end of your service, but as I said in my opening, we are also probably at the most difficult part of your service, and we all understand that. I want to start by saying justice will be served. Isaiah Chance will spend the rest of his life in prison, punished away from society. All we are asking is that you spare his life. Death is never required. The death penalty exists for the worst of the worst. We submit that Isaiah Chance is not that. As I said, he will pay for this crime every day for the rest of his life. We are asking you to let him have that life. This is going to be a conversation about life, a request on behalf of a young man and his family, Isaiah Chance, someone from Jacksonville, lived with his mother, who sat in his grandmother's lap, who called his father all the time, went to Atlanta to be with his grandparents. A man with 3 children. That's who you are deciding about today. A man who spent every day of his life working harder than those around him, just trying to keep up and working harder to make it seem like he wasn't doing that. You heard from 6 people and a doctor, 6 people who love him and a doctor from that chair, and they told you who he is. They're asking for you to believe them and to listen to them. The law gives you this phase of the trial for a reason. You have decided guilt. We are past that. It asks you to decide who Isaiah Chance is and who he is and how he got to be that if he's worth saving. As Ms. Finkelstein said, mitigation does not excuse. Mitigation explains. I'm asking you to look at Isaiah Chance, the full human being, and decide whether death is appropriate, if death is the answer. And death, we would argue, is never necessary. You heard from his entire family during the penalty phase, and like I said, a doctor. 7 different witnesses from 7 somewhat different vantage points, but all told you essentially the same thing. From Victoria Gray, she described his mother. She described him as quiet, gentle, close with his family, never violent. Someone who really didn't want to play football, who had goals. He wanted to be a merchant seaman, an entrepreneur. He was trying to build something. She told you him and his entire family had hobbies, I think she said martial arts, that they would do together because they loved each other and they genuinely wanted and loved to be around each other. Think about her, what it takes to raise 6 children, not on her own, but in large part on her own, in Jacksonville, and each one of them know that they are loved. Isaiah Chance clearly knew he was loved by his mother. He told you that himself through his interviews with the doctors. He told you that by how he acted with his father, how he acted with his grandparents, how he acted with his children. He got that from his mother. She gave that to him. It didn't come from nowhere. You heard from Isaiah Chance Sr., a United States Marine, who after serving came back to Jacksonville, who after getting divorced from his mother stayed in his child's life, stayed in Isaiah Chance's life. When he would help him with his schoolwork, he saw him struggling. And he said, hey, that reminded him of himself. You're like me. I struggled. Keep going. I see you. Not an excuse, but just, I see you work. I see you working. He told you something else. He said that Isaiah called him all the time. And every time he hung up the phone, he said the same thing beforehand. He said, I love you, to his dad. Every single time. Something so ingrained, it was subconscious or subconscious, but he said it. No one's listening when you're talking to your father on the phone. It's not performative. It's just something you do. And he decided at some point, like I said, maybe subconsciously, that every time he talked to his dad, he wanted to let his dad know that he loved him. That is not something, again, that he decided to do performatively. That just shows you that's him as a son. Heard from his grandmother, Elizabeth Jordan, Nana, I think she said. She said he used to sit in her lap when he was a baby, and if he could, he would do it today. She told you that her and Papa used to take the grandchildren on vacation and take them to church. They were there for the grandchildren, and when they needed Isaiah, he was there for them. She told you when Papa was sick, I believe 7 days he was in a coma. Isaiah Chance didn't call and see how he was doing. He didn't text and see how he was doing. He showed up. He stayed at the hospital until he woke up. And then when they needed someone, when Papa wanted to go home to be with his wife in Atlanta, she couldn't care for him on his own, they called Isaiah Chance. And he showed up time after time. I think it's, like a 5-hour drive from Jacksonville to Atlanta? And he made that over and over again for years to be with his grandparents, to help take his 260-pound grandfather out of bed when his grandmother couldn't. When he was 19, 20, and 21. When most kids are thinking only about themselves, Isaiah Chance realized that when family calls, you show up, and he did that. I think that's an important part of Isaiah Chance and who he is, someone with value. And I ask you to remember that as you deliberate. You heard from Michelle Smith, his godmother. Knew him, she said, before he was born. Had a good relationship with him, and she said she would always tell him the truth. That's the AC kicking on, thankfully. She supported.
I'm sorry to interrupt you. It sounds like the AC has kicked on, and so Mr. Petraeus, just if you can try.
Yeah.
Just now, it sounds like a windstorm over there. So.
It's a good thing, though.
Yes, it is a good thing.
You heard from Nashawn Nix, his former stepfather, his mentor. And he was someone I thought was a very important witness. He's not blood related to Isaiah Chance or his mother, obviously. Didn't have to be here. He was in Isaiah's life from 7 to 12, so a little while ago. And he built an organization whose entire purpose was identifying young men who can be reached and investing in them. And he saw many that couldn't be reached. And he showed up here. He told you when he was with Isaiah, he noticed things. He would go to school meetings. He would talk to him after school. He would talk to his guidance counselor. He noticed things the family saw as well. He was pushing for tutoring, for structure, and for support. And years later, after he was out of Isaiah's life, no longer with his mother, Isaiah Chance needed a letter of recommendation to be a merchant seaman. And he went to Mr. Nix. And Mr. Nix saw something in Isaiah Chance, and he put his reputation on the line, and he wrote that letter of recommendation for him. That's not obligation. That is not sentiment. It's a man who spent his career learning to see who people are, and he saw something in Isaiah Chance, and we're asking that you see the same thing. You heard from Miss Wade. She's known him from about when he was 16 years old to when he was becoming an adult. She said when she needed someone to house sit, when she needed someone to pet sit, and anyone who knows pets knows that that's a serious obligation, someone to let someone else watch their pet, she called Isaiah Chance. She never had any issues. She never had any trust issues. He did it every time. That's not someone you let do that unless you genuinely trust that nothing will happen. And she told you he would talk to her about his plans for life, specific plans, his goals, what he wanted to accomplish. And she plans to stay in touch with him while he's in prison. Tells you everything about what kind of person inspires that kind of loyalty. 6 witnesses, 6 different relationships, telling you 6 different years of Isaiah Chance's life, different eras, all telling you the same thing. He was quiet, respectful, gentle, loving, nonviolent. A young man who needed a little more structure than the world gives to most people. Then there's the science. Dr. Tracy Hardig, forensic psychologist. She spent hours with Isaiah Chance. She did actual IQ and academic testing. She reviewed school records going back to when he was in preschool. But before that, let's talk about what she said when she noticed him. He was quiet. He was mild-mannered. He wanted to be there. He wanted to do the test. He was not depressed. And he kept saying the same thing essentially throughout the testing. I'm smart. I know I didn't do great in school, but he wanted to impress her. And he used some big words, and I would say he used some correctly and some incorrectly, like he did with Dr. Warner. He got a full-scale IQ of 71. That's what she got through the testing. At age 22, he reads at a 5th grade level. His math is at a 3rd grade level. The things that a lot of us take for granted in life that we get through life are genuinely harder for Isaiah Chance. Not impossible, just harder. She reviewed his Duval County school records, which I believe Dr. Warner glossed over. He had 3 tests done in school, and they all said the same thing at ages 4, at ages 10, and ages 12. 3 different other evaluators, independent. At age 4, said he had issues with speaking, and we heard from multiple of his witnesses telling you that he was nonverbal at that time. So corroboration. At age 10, he got the same score as Dr. Hardig got, corroboration. And at age 12, he was even a little bit lower, again. And then he's removed from that school. People with IQs in this range are not unintelligent. They can form relationships. They can have jobs. And we're not asking you to weigh his IQ as an excuse, but just as context, something you can weigh when you're back there deliberating on mitigation. She also diagnosed ADHD, and the clinical observations you saw from school showed the same thing. Off task over 30% of the time, way more than his classmates, and it was never treated. The state talked about a co-defendant not having IQ tests because they didn't provide corroboration, and they talked about that as a bad thing. Well, we have corroboration from 3 IQ tests, and they don't want you to look at that, and I'm asking you to look at those IQ tests that corroborate Dr. Hardig's and go against what Dr. Warner said. And the last thing I want to say about Dr. Warner is she said that she trusted the testing that was done in school, trusted the testing that Dr. Hardig did, trusted and agreed with the results of both, but disagreed with the diagnosis, which is based on the results. I would say that doesn't follow. We also heard that he could be vulnerable in the wrong environment. He has a lifelong need to belong, and that's a human, that's a character. It's not a character flaw. It's just a human need. But I want to talk about what the right environment looked like. That looked like what Mr. Nix provided. When Mr. Nix was there, when he provided structure, when someone was paying attention, made real progress. Isaiah made real progress. It tells you something. Isaiah Chance is not someone who's beyond reach. He's someone who does better when someone is paying attention. We're not here to ask you to believe that he will never struggle again. We're asking you to believe that struggle will be worth it, that he has value, that it matters, that he is not what happened in the worst moments of his life. Now, the state pointed to the aggravators. They spent a lot of time on the aggravators, and we're not here to minimize what happened, not at all. We're not here to argue those either. We're here to talk about this young man, him as a human being, about things that make his life worth saving. We're here to tell you we believe the mitigators outweigh the aggravators. Like Ms. Finkelstein said, you're going to get a list of the mitigators. I'm not going to go through all of them. I do want to go through a few of them. And you give whatever weight you believe to these mitigators. Isaiah Chance has no significant history of prior criminal activity. You heard from his mom and his dad, no arrests, nothing. His age at the time of the crime, he was 21 years old at the time of this crime. He was a young man. Like I said, he suffers from borderline intellectual disability and untreated ADHD. His loving relationship with his children, which I'll get into in a little bit. His loving relationship that you heard from his family and friends that goes both ways. Isaiah Chance did not carry, use, or threaten to use a firearm during the commission of this offense. Let me be clear, this in no way lessens his guilt. But it is a fact that you can consider when you're back there, that he did not have a firearm during this offense. And again, there's the catch-all. Anything else you heard from any witnesses on that stand that you saw, that you believe is a mitigator, you can use. Isaiah Chance is a son, a brother, a grandson, and father whose life has meaning to others. His children, Kabri, Kylan, and Amiri. His mom told you he was a great father. He wanted to be involved with his kids. Miss Wade told you he was always calling her, asking her for advice. He wanted to be involved. He was present. He was trying to be a good father. He was 21 years old with 3 kids, actively seeking out guidance to be a better father. That is not the behavior of someone who doesn't care. That is behavior of a young man who understood that fatherhood mattered and was trying imperfectly to rise to it. He cherishes fatherhood and has a great relationship with his 3 children. That is not nothing. For a 21-year-old who may have some limitations, trying to figure out how to be present for 3 children, that effort means something. It tells you something about who he is when the stakes are personal. He showed up for his children just like he showed up for his grandparents. It's not a legal argument. It's a fact about what it means to be human. His kids are growing up right now. One day they will be old enough to know their father, to write him a letter, to ask him a question only he can answer. And he will be in prison. But a father can still be a father behind bars. A letter, a phone call, a presence. We are simply asking for you to leave that door open. 7 people testified in the penalty phase. 6 who have known him parts or all of his life, and a doctor. Dr. Hardig told you the clinical side. People like Isaiah are a little more vulnerable. They want to belong. They want to follow because it's safer than the alternative. He spent his entire life working harder than other people, failing and trying again. He put his family first and truly sacrificed on multiple occasions when it mattered. He sat in church with Nana and Mr. Nix and talked about God and life. He was a great brother and a great and attentive father. He was someone's son, someone's grandson, someone's father. He's a human being with limitations and with love. You heard about the continued support he will get while in prison. On behalf of his mother, who raised him with structure and love, his father, who is there for his son and still wants to be there for his son, Elizabeth Jordan, who he sat in her lap his entire life, and Nashawn Nix, a man who owes him nothing but showed up here to tell you that he loves him, and he better know that he still loves him. We are asking you to spare his life. The family did not need to come here. They chose to. They sat in the witness chair knowing everything that you know, and they want to tell you that this person is not beyond saving. They're not in denial. They know what happened. They still came here, and they're still asking. That says something about Isaiah Chance that no test score or school record can fully capture. It tells you the people who know him best, who have seen every version of him, have decided he's worth fighting for. And we are asking you to agree with them. The death penalty is reserved for the worst of the worst. And we would argue that Isaiah Chance and the facts of this case do not meet that criteria. He's not the kind of person for whom there's no threat of redemption or no evident conscience that the death penalty was designed for. Death is never required. Again, as I say in my opening, the law favors life because it always gives you the opportunity to give mercy. We are asking you to consider that a person can do something unforgivable and still not be beyond the reach of mercy. Isaiah Chance will spend the rest of his life in prison. He will carry what happened to him every day. We are not asking for you to forgive what happened. We are not asking you to forget it, minimize it, or look away. We are asking you to look at the full human being, everything I've talked about and everything you've heard from the stand, and decide that death is not the answer. Justice will be served. He will spend his life in prison. Today's the last day he's going to wear street clothes. Last time we'll put a suit on. Mercy does not mean forgetting. Mercy means choosing deliberately and with full knowledge what you know to let someone live. The law gives you that option, gives you the option for a reason. We are asking that you use it. We are asking that you spare Isaiah Chance's life. Thank you.
Okay, very good. Ms. Toomey, on behalf of Davion Murphy.
Good morning. Davion Murphy was born January 10th, 1997. A blank canvas, wide-eyed to the world, not knowing his limitations, not knowing good from bad. But children learn what they see every day. When children learn criticism, they learn to condemn. When they learn hostility and violence, they become violent and fight. When children live with instability, they become unstable. Now, as I told you in my opening, Florida has no parole. There's no gain time. As Davion Murphy sits there now, and all of these other defendants, they will be given life in prison. The only question for you is when he dies, either by natural causes or by execution. That's the only decision that is left to make. And this is probably the most important decision that you will make in your life. The fate of another human being is in your hands. I want to pose a question to you, and that is, what good comes from executing Davion Murphy? It seems like a simple question. It's not so simple. I think it was Gandhi that said, an eye for an eye eventually leaves everyone blind. There is no need to execute Davion Murphy. Life in prison, a life along with thinking about this every single day, perhaps even maybe walking down the same hallway as his father, stomping the same concrete in those hallways in the Florida Department of Corrections as his father, his uncle, his younger brother that testified, his blood cousin, Rashad Murphy. A vote of death will only be the next statistic in this gang war that started in Jacksonville. It'll be just another statistic. And what comes from executing another human being? Nothing comes from it. It's not going to bring Charles Jones back. It's not going to change the events that occurred on June 23rd of 2023. It simply perpetuates the violence that started long, long ago, not here in Hillsborough County, but in Jacksonville. As you heard from the state's witnesses, the detectives, the gang detectives, so much violence so in these gangs that they have detectives that are given certain gangs to follow. That's what Davion Murphy grew up in. He grew up in East Jacksonville. Davion Murphy wasn't born into a life of privilege and opportunity. He was born into violence and instability. What chance did he have? And folks, I'm not offering you an excuse for these events or what happened. It's tragic. I'm simply offering you context of the facts. Context. Davion Murphy was 12 years old when his father, who suffered from schizophrenia, was given life in prison for murder, along with his uncle, his parental uncle, who also was given 50 years in prison for murder. When he was 12 years old, his father was gone, absent from his life. And you heard from his youngest brother, Adam Gooden, his youngest brother, who broke down in front of you all. Well, they grew up in the same environment. They had the same mother. They had different fathers. But if you recall, Adam Gooden also told you that his father was incarcerated in prison. This is a generational violence, instability, insecurity that these men grew up in. When I say these men, I mean Davion and his cousin. And you got to see this firsthand through the state's witnesses, their detectives, as well as through the individuals that testified on Davion's behalf. Take a technically, intellectually disabled child with learning disabilities, throw him into the violence and crime in the streets of Jacksonville. What happens? They look for comfort. They look for a father figure. What becomes the father figure for them? The streets, the gangs. Now, as you saw, not only did Dr. Eisenstein, and we'll get to that in a moment, but Dr. Eisenstein testified that he was borderline intellectually disabled. They had long ago indicated that Davion Murphy had a mental disability. He was in special classes, he was in IEP classes, he had to repeat various grades, and he also suffered traumatic brain injury from all the various events that occurred in his life. Multiple motor vehicle accidents, fights, falling off a golf cart, or running a golf cart into a tree. And folks, these scans, these images weren't done because he was found guilty. The state knows better than that.
Judge, objection, that's an improper statement. It's a misstatement of the law, and that's improper.
Yes, sustain the objection.
These scans were done to show you that Davion Murphy suffers brain damage. What does Dr. Rubino have to come in here to risk his medical license to say, and you saw the scans, and you can take it back if you want to look at them, to say that he suffers from brain damage? And the state had its radiologist, a diagnostic radiologist, of whom I respect, Dr. Glickstein, I respect, but he doesn't have the knowledge and the upkeep of the new technologies. He wasn't able to, he hasn't seen he said, I think it was like once an MRI, DTI, which is commonly done in these radiology facilities. Why would a neuropsychologist recommend scans that a neurologist send to a radiology facility that then conducts the scans and gets those images, perform those? It's a big liability there. I suggest to you that he does have brain damage. You can watch the interrogation video yourself. That's demonstrative evidence of the state of mind of Davion Murphy and his intellect. Now let's talk about a little bit about mitigation. As you've heard, it's not a numbers game, it's not a calculation, it's not who's got more mitigation. It's about the weight and the significance of that mitigation. I'm not going to address the aggravating factors. I'm not going to waste your time. I'm not going to insult any one of you. But the mitigation that was presented on behalf of Davion Murphy is substantial and is great, and it deserves great weight. And you also have to remember that the mitigating circumstances have to be proven, not beyond a reasonable doubt, but by a preponderance of the evidence. I submit to you that Dr. Eisenstein, who met with Davion Murphy 7 times in person over the course of 6 months for over 20 hours, has a better idea, a better understanding of what Davion Murphy is about, not Dr. Warner, who met with him by Zoom for 80 minutes. And then when asked by the state about why she had such limited time, was because the jail only gave her 3 hours or something like that. Well, if you only had 3 hours, then say you need enough time. You didn't have enough time. You can't render a proper diagnosis or render an opinion because you didn't have enough time. Dr. Eisenstein had enough time. He took the time to know Davion Murphy, went through his records, his medical records. And why did we not provide Dr. Eisenstein with police reports, videotape interrogation, videos and such? Because we wanted to make sure that there was no bias, that Dr. Eisenstein met with Davion Murphy, without any bias in his mind. That's why. I suggest to you that Davion Murphy's life is worthy. Davion Murphy is worthy. That he is redeemable. That he's made a grievous mistake. And that he should be punished. He will be punished. He's being punished every day. And he will be punished every day for the rest of his life. There's no doubt. But it's your job to look at him as an individual, all of these defendants as individuals, and not compare one to the other, but look at each of them as an individual person, and then decide whether the mitigation, which has a lower burden, and rightfully so, has been proven in substantially or outweighs the aggravation in this case. It has to make the crime more grievous. It doesn't. Life is the appropriate sentence. There's nothing that a death sentence is going to do in this case. So the mitigators that you have on behalf of Davion Murphy is the capacity of Davion Murphy to appreciate the criminality of his conduct or conform his conduct to the requirements of law. That's one. He's got 13, but once again, it doesn't matter. It doesn't matter if you've got 50 or if you've got 100 and it's not a numbers game. It's not who's got more or who's got more aggravators versus mitigators. The second one, the capital felony was committed while Davion Murphy was under the influence of extreme mental and emotional disturbance. That's where Dr. Eisenstein comes in. That's where Dr. Rubino comes in with their testimony. The age of Davion Murphy. He was 27, but when you consider the testimony of Dr. Eisenstein, the age of the person on the outside isn't necessarily the age of the person on the inside. Davion Murphy suffers from traumatic brain injury. Yes, Dr. Rubino testified that he did. And doctors, they disagree. They do disagree. You have to decide who you believe. And once again, we don't have to prove beyond a reasonable doubt that these mitigators exist. Just a preponderance of the evidence, greater weight of the evidence. Davion Murphy is in the borderline range of intellectual disability. Let's talk about Dr. Warner for a minute. She indicated that he was low average, I think is what she testified to. But she's not, doesn't have the ability to do any psychological testing, didn't do an IQ test, didn't do really basically anything. She did a mental status examination of Davion Murphy. That was not rebutted, wasn't disproved. Davion Murphy did not have a stable role model in his life. No, he did not. Neither did his younger brother. Davion Murphy's father was diagnosed with schizophrenia. Yes, you heard from Winston Murphy, who was very reluctant to testify, but yes, that was his brother, and he testified that his brother, who is Davion Murphy's father, was diagnosed with schizophrenia. Davion Murphy's father was incarcerated for life when Davion Murphy was 12 years old. Yes. Davion Murphy took on a parental role for his younger siblings. Yes, because he had to. I think Adam Gooden testified that he had to sell, or they would sell a PlayStation or something like that to get food. Davion Murphy is loved by his family. Yes, yes he is. And then the existence of anything else. That means that mitigation to you can be anything else that you decide it to be. You get to decide. Maybe it's something I didn't say or wasn't presented to you. Maybe it's something that just because. Just because you think life is more appropriate than death, than execution. Because this vote is individual to each one of you. It's an individual moral judgment that each one of you have. Yes, you have to go back and discuss the evidence and things, but it's your vote. It's not anyone's vote, and don't let anyone else try and convince you of what your vote should be when you go back there. It's your decision. Folks, gang violence tears apart families, neighborhoods, and futures. And that's exactly what it did with all these families, Charles Jones' family. The death penalty only guarantees that suffering and that violence continues. Life in prison for Davion is a just punishment. It removes him from society. And we can be tough on crime without the death penalty and just giving him life in prison. Now this is the verdict form. And once again, just like in the guilt phase, excuse me, just like in the guilt phase, just because you didn't hear from Davion Murphy, like you heard from Shan Gathright in the penalty phase, doesn't mean you can hold that against him. He's got the right to remain silent, and you cannot use that against him. Just want to remind you of that. For any of the defendants that did not testify in the penalty phase. But here's the verdict form. It's 3 pages long, but on that second page is where it has jury recommendation. And you might think, well, it's just a recommendation. It is, but your recommendation will be given great weight by the court. So when you vote, it's going to be the vote. It's going to be the deciding factor as to what these individuals get, life or death. If fewer than 8 jurors vote for the death penalty, your recommendation must be for the penalty of life in prison without the possibility of parole. Fewer than 8. That means 7 of you can vote for death, 5 of you can vote for life, and they will get life. I submit to you that you really don't need to even get there, folks, because you could just go right to the bottom and find that Davion Murphy should be sentenced to life in prison without the possibility of parole. That is a just punishment in this case. This is not the most aggravated of murders and the least mitigated. What good would it do to execute an intellectually challenged, brain damaged 29-year-old male who's grown up on the streets of Jacksonville just trying to survive the gangs and the violence? He lived and did what he saw every single day. he's going to be punished enough. You can tell Davion Murphy that he did a terrible thing. This is terrible. It's tragic. But you can also tell him that he's redeemable and he has worth with a vote for life. Thank you.
Thank you, Ms. Toomey. And Mr. Hernandez, on behalf of Rashad Murphy.
Please, the court.
Yes.
Counsel. Good morning, ladies and gentlemen. I want to begin again by thanking you very much for your service, your attentive service in this case. As you know, I am speaking on behalf of Rashad Murphy. I cannot imagine an attorney having a more overwhelming responsibility than advocating for a man's life. And here we are. As we go through the evidence that was presented and the mitigating circumstances that have been proposed, I want to make sure that there is no attempt to misstate. If I say something, I've got notes, you have your notes. If I say something that you remember differently, please rely on your notes and your collective memories. You've heard it several times during this case, and I'll go briefly through it. Your recommendation is extremely important. It carries great weight. The judge has to give it great weight. And the mitigating circumstances that have been proposed by Rashad Murphy and the other defendants only have to be proven by the greater weight of the evidence. If you believe that it more than likely exists, you can consider it and give it the weight that you decide it deserves. And those mitigating circumstances can be facts about the case, or it can be facts related to Rashad Murphy as a person, as a human being, such as the mental issues that have been presented, his childhood, his history, his accomplishments. It can also be your personal observations of Mr. Murphy's behavior during the last 6 weeks, as you've had a chance to observe him for 6 consecutive weeks. And your vote, although you deliberate, each vote is individual, and although there is a weighing process, you ultimately are being asked to decide what is the appropriate vote, either a life recommendation without the possibility of parole or death. Ladies and gentlemen, nothing that I am saying during my closing arguments is designed to in any way minimize the tragedy for Charles Jones and his family. Death resulted regardless of the details. His family, the family of Mr. Jones, grieves regardless of the details. All that is a given before your analysis in this penalty phase begins. And the same principle applies to the crime of murder. All murders involve some level of violence, some less, some more, but they all involve some level of violence. All first-degree murders involve either premeditation or while committing a serious crime such as robbery or rape. Nevertheless, and that's why we're here, nevertheless, not all first-degree murders warrant the death penalty. And I submit to you that in the case of Rashad Murphy, the death penalty is not warranted. but we need an analysis of the facts of the case, but also of the person who Rashad Murphy is. You heard from several family members. You heard from his fiancee, Charmaine Staker, and the mother, his fiancee, that they've known each other for, I believe, 15 or more years, and the mother of his 4 children. You also heard from 2 of his aunts, Hazel Dickerson and Jamila Murphy, as well as his uncle who's in prison, who testified here as well, Winston Murphy. They all made it clear to you that they love him very much and that he has a lot of redeeming qualities. They all confirmed, in one way or the other, they all confirmed Mr. Murphy's difficult childhood, his personal history, being an excellent father and brother to his siblings. They all had some knowledge, some more, some less, of the physical and emotional abuse that Rashad Murphy suffered growing up, that he witnessed gun violence and lived in a high crime area, that he was raising 6 children when he was arrested in this case, his 4 children and 2 of his younger siblings. And despite working and having a limited income, he was raising 6 children. You heard that he was consistently employed, and that you also heard from Ms. Steger, his aunts, that they would continue to have contact with Mr. Murphy and visit him in prison as he would be serving if he ultimately gets a life sentence without the possibility of parole. And with something that Mr. Harmon said yesterday, I want to make it clear, and I think you would agree. The fact that he has some loving family members, such as his fiancee, but going back to his childhood, having 2 loving aunts, does not in any way erase the extremely difficult childhood that he had without a father and with a mother with a serious drug problem, and obviously he was taken out of the family home and placed into foster care because of that. You also heard from Dr. Collins, a licensed psychologist. He testified and has previously testified as an expert in neuropsychology. He was appointed by the court and paid by the state of Florida. He was asked by me to evaluate the defendant, Mr. Murphy, and possibly testify in this case, which he did, obviously. Before he testified, he was provided reports, not everything in the case, but provided records to review. Some about the case itself, so that he would have a sufficient amount to become familiar with the facts of the case and the evidence in the case. But also about the defendant, before he even sees the defendant at the jail, things that would give him knowledge of the defendant as a person, his background, his childhood history, his mental history, jail records, because by that time he's been in jail on this case for a period of time. And then he has contact with the defendant on 2 occasions. I believe his testimony that he ultimately spent a total of 7 hours with Mr. Murphy. Part of that contact is to interview him, just chit-chat, have a conversation with him. And the purpose of that is to get to know him, to find out, to determine whether he is going to be cooperative, and whether he is going to provide truthful information, because whatever he says can be compared to records that he's had a chance to review. And then part of that time is to conduct psychological testing, standard accepted test to analyze and diagnose. Dr. Collins testified, and none of this really is being refuted by the state. He was cooperative. There were tests done to find out if he was in any way faking and malingering. That was not the case. He was definitely cooperative and not malingering. The important thing, or at least one of the important things, is that the interview, the testing, and the records that were reviewed by Dr. Collins were all consistent, clearly indicating that Mr. Murphy was being truthful regarding his self-reporting about his childhood, about his background, about his history, and about his mental state. Dr. Collins testified that Rashad Murphy suffers from anxiety and depression stemming from childhood trauma that would be intensified throughout his adulthood. That he, Rashad Murphy, was physically and emotionally abused by his father, by his stepfather, and in the foster home. And that his mother suffered from severe drug addiction and ultimately died, where leaving Mr. Murphy with having to, by this time he's of course out of the foster home, and having to take care of his younger siblings. He confirmed, Dr. Collins confirmed, that drugs and violence were common in his community, in the community that Rashad Murphy grew up in when he was not in foster home. Ladies and gentlemen, I'm trying not to be repetitious, but the fact is that Rashad Murphy was born into violence and suffered a lot of abuse and neglect. He was removed from his father's care by the state when he was a small child. And all of this is confirmed by Dr. Collins, not just talking to Rashad Murphy, but looking at all the records. And then, as I said a minute ago, is that back after, I think it was 2018, when his mother died, he adopted his younger siblings. He was employed, but obviously a limited income, trying to not only financially support his fiancée, his 4 children, but also his 2 younger siblings. Dr. Collins also confirmed other records, and of course you've heard from Ms. Steger, that he had a loving relationship with his childhood sweetheart and mother of his 4 children, that he was an excellent father, hard worker throughout his adulthood. The diagnosis by Dr. Collins is that Mr. Murphy suffers from post-traumatic stress disorder, PTSD. And as you know, it's a mental condition triggered by experiencing and or witnessing terrifying events. And it disrupts daily life. It affects his judgment, his decision-making as an adult. And it goes back to his childhood. Once someone has PTSD, it doesn't magically go away. It can be treated with psychotherapy and medication, but his condition is always there and does not go away, and it relates back to his childhood. And again, I should point out that, and I'll get to it in a minute, that Mr. Harmon, on cross-examination, I think, tried to discount it somewhat, but there was never anything presented by the state refuting this diagnosis. There was also the fact that his father, Rashad's father, had mental problems. That was documented. And also that Mr. Murphy's condition was noted in the jail records by state doctors before Dr. Collins even got involved. So you have corroboration that is and not disputed by the state, discounted, but not disputed. There's no expert saying otherwise. You also, through the testimony of Dr. Collins, you heard that several examples of Mr. Rashad Murphy trying to help himself, better himself as a person while in prison. Ladies and gentlemen, that evidence has more than one indication. I suggest to you that it does show that he's trying to better himself as a person, but it also shows that it's indicative of him not being a troublemaker, adapting to prison life, following strict rules and regulations, that if he was sentenced to life in prison without the possibility of parole, he would not be a problem, a troublemaker in prison. He's been in jail 2 years without any problems. And as I said, trying to better himself, you have the exhibits that you can look at when you go back to deliberate. There were 3 composite exhibits presented to you. One is Defense Exhibit 1 dealt with education. He got his GED while in prison, while in jail, not prison. He got his GED while incarcerated on this case. He also, there's a series. Defense Exhibit number 2 has a several, I forget how many, 8 or 9 attached to that exhibit about different religious certificates and classes that he's attended, different religions, just showing religious awareness. But it also was presented during the testimony that he not only has been taking these classes, he has been teaching some of these classes to other inmates. He serves as a mentor in prison, in jail. I keep saying, I don't mean to say prison, Hillsborough County Jail. And then Defense Exhibit number 3 is a composite of certificates dealing generally with self-help, parenting classes, dealing with Alcoholics Anonymous, emotional regulation, things of that nature. And ladies and gentlemen, I think what I'm saying, it feels it's too obvious to mention. None of this testimony and exhibits are offered as legal defenses or excuses for the homicide. But as you know, all first-degree murders are inexcusable. But they certainly are offered as valid mitigating circumstances, showing that the defendant, Rashad Murphy, has many redeeming values, showing that a life recommendation is appropriate. The court, when we get to part of the instructions, when we get to specifically Rashad Murphy, the defense is offered to you a series of proposed mitigating circumstances, and that they will be read to you. One of them, and I think there's a couple that have to do with the fact that he has no prior criminal history, and we'll talk about that in a minute. No prior felony convictions. There's also a couple, they're kind of interchangeable, that Rashad Murphy, his age at the time of the offense, he was only 30 years old when the homicide occurred. There's no dispute of this. It's there for your consideration. The state never is not disputing it. It was stipulated to. Another proposed mitigator is Rashad Murphy has a history of physical and emotional abuse as a child consistent with childhood post-traumatic stress disorder. You heard from Dr. Collins. You heard from the record from the jail doctors. I think there's certainly corroboration of that, and again, something that has not been refuted by the state. You will also hear that Rashad Murphy has maintained a loving relationship with family and friends while incarcerated. And again, you heard that from the fiancee, Ms. Steger, his uncle, and his aunts. Another proposed mitigator is that Rashad Murphy has developed religious and spiritual awareness while incarcerated. In fact, you heard testimony that he was religious before, but certainly the exhibits and his family's testimony corroborate that. Also, Rashad Murphy helped raise his younger siblings, including working jobs at a young age to provide family support. Certainly that was corroborated by the records and by the testimony of his family. And the same thing with the next one, which is Rashad Murphy as a minor was removed from his primary home and placed into foster care due to negligent and abusive situations in the primary home. Also, Rashad Murphy has displayed appropriate behavior and the ability to follow rules while incarcerated. And again, that's corroborated not just by the exhibits and the records. He has been no problem whatsoever while he's been incarcerated. And that's an indication of what type of prisoner he would be if he is sent to prison for life. You also are being told the existence of any other factors in Rashad Murphy's character, background, or life, or the circumstances of the offense that would mitigate against the imposition of the death sentence. And we'll get to, I will touch base on some of these mitigators, but if there's something I forgot, something that you believe in your observations or hearing, please rely on that as well. Now let's go back to some of these. His age, which is two of the proposed mitigating circumstances. He was 30 years old at the time of the homicide. He's presently 32 years of age. To some extent, I would suggest that that age is an interesting number. He's still a young man. He's still a young man. He was only 30 at the time of the offense. And it certainly, that alone is offered as a significant mitigating circumstance. However, it also is old enough to have established a pattern, good or bad. It's certainly at the age of 30, you've been an adult for 12 years. It's certainly old enough to have become a career offender. But here we have no felony convictions whatsoever. So here we have 12 years of adulthood to look at, and we have a good pattern. With his background and environment, with the violence surrounding him, with the abuse inflicted on him, I suggest to you that it's extraordinary that he made it to the age of 30 with no criminal history. Let's go back a minute to the PTSD. As I said before, the state is not refusing the mental condition. And no state doctor testified saying, refuting the opinion of Dr. Collins. I think it's fair to say that the state is suggesting that considering everything, it's not important because you found the defendant guilty of first-degree murder. And as I said before, it's not offered as a defense, but it is presented to you as a significant mitigating circumstance for your consideration. And I think it's somewhat disingenuous for the state in their cross-examination to imply that the defendant's mental condition is normal for someone who's incarcerated. Of course, being in jail, getting arrested, got to be stressful. But that's not what we have here. The defendant's childhood is not normal. Getting abused by his father and stepfather is not normal, ladies and gentlemen. Growing up in the violent environment is not normal. Being abused at the foster home is not normal. Neglect due to his mother's addiction is not normal. Touching back briefly on his behavior while he's been in jail on this case, and as I said, it shows that he knows he's not he doesn't cause trouble at the jail. But I think it should be emphasized that he can be, in addition to having contact with his family, he can be a positive influence on other prisoners. He's been teaching Bible classes. He can mentor other inmates, now in jail and later in prison. And as I said, he would, as you've heard testimony, the evidence has shown and his behavior has shown that he would continue to be able to maintain a living relationship with his family and friends while in prison. Ladies and gentlemen of the jury, all first-degree murders are not the same. That's just the bottom line. And that's a decision, a vote that you have to consider. The facts and circumstances are always different. All defendants convicted of first-degree murder are not the same. And, of course, as a corollary to that, not all first-degree murders warrant a death sentence. I suggest to you that the death sentence should be reserved for the worst cases. All murders involve the death of a human being. All murders involve some level of violence. But here we don't have any torture. We don't have multiple deaths. Here we don't have separate incidents. It was all one event, a terrible event. I mean, there's no way to describe it otherwise. A terrible event, but only one contemporaneous event. You determined justice. You determined justice was served with your verdict. As you've been told more than once, Rashad Murphy will die in prison regardless of your vote. And based on your verdict, a severe punishment is appropriate, and there's only two choices. I submit to you that justice will be served. It will be further served by severely punishing Rashad Murphy by making him spend the rest of his life, which according to normal life expectancy could be another 50 years, to spend the rest of his life in prison, to live under strict rules and regulations without the basic freedoms we normally take for granted, that we normally enjoy. And I'm trying not to be repetitious, but I need to go back for a moment to this lack of any prior felony convictions. I cannot, ladies and gentlemen, I cannot overemphasize this. Despite the terrible environment the defendant grew up in, despite those scars, despite the mental ill issues he lives with on a daily basis and will continue to live with, despite whatever treatment he gets, The defendant, Rashad Murphy, has no prior felony convictions, not one. And I ask you, when you decide on your vote, compare that fact, that stipulated fact, to a career offender. Compare that fact to someone who has a prior record of similar crimes or violent behavior. Compare that stipulated fact to the state's argument that the attempted murder served as an aggravating factor despite being only one contemporaneous event. Compare that stipulated fact to the state's argument that an aggravating factor is that the defendant was a criminal gang member. All that, all those allegations, all those factors, despite the fact that he has no prior felony convictions. I submit to you that the mitigating circumstances outweigh any aggravating factors presented by the state. But in any event, I submit the mitigating factors clearly show that a life recommendation is warranted with respect to Rashad Murphy. Ladies and gentlemen of the jury, I have not offered this evidence or made this closing argument to in any way justify the homicide. My only point is that the evidence presented, all corroborated, demonstrates that a life recommendation is appropriate for Rashad Murphy. And finally, I want to talk about Rashad Murphy's children. 2 sons, 2 daughters, between the ages of 7 and 13. Pretty much the ages that the defendant was when he was experiencing some of this abuse and separation from his family growing up. Despite being in prison for the rest of his life, he was an excellent father, he is an excellent father, and he can still be a positive influence on his children. He has been and would continue to be a loving and supportive father. Please let him carry on as daddy to Major, to Avery, to Prosper and Gabrielle, guiding them to do the right thing. Thank you.
All right, thank you, Mr. Hernandez. Okay.